Hello everyone, welcome to a brand new video of German Talks, and I hope you're doing safe and excellent as always. Today I have come up with this topic of non-disclosure agreements and what constitutes the best structure of a NDA and what should be what are the must-haves in any non-disclosure agreements. I'll come up with some interesting anecdotes, so please stay tuned till the end of the video and I'll hope you'll find it interesting. So let's get started. Okay, so first comes the definition part. What is an NDA? Well, it is actually a legal document or an agreement designed to protect the confidential information from being disclosed to a third party or being used for purposes other than the ones which are intended. So, unintended purposes. Well, it is one of the basic or a starting document to have between two parties when before they begin their contractual relationship. And depending on the depending on the nature of business, it's single or bi-directional. In single directional, it's only one person, one party is the downstream of data, one is in the upstream. So this is the party which is the receiving party of the data. This one is the giving the data is originating from here. So in these situations, a single NDA, single way NDA is there. In certain cases, it's a mutual NDA. In certain more cases, they are tri-party or multi-party NDA. That depends if there are a number of stakeholders involved. Well, NDA are nothing new. Like I said, in technology contracting, at least to say, because they actually at least intend to do the safeguarding of the confidential information, trade secrets, and such kind of information. They are generally very important in the pre-merger situation, pre-mergers and acquisition. So, well, they have quite a gamut of use, and but what actually is the best NDA strives for? Well, they any good NDA should encourage compliance. It should like disencourage any unintended or non-compliance, so to say, and it should promote enforcement. Now, compliance and enforcement are different. It should like lay down certain rules which actually says that this has to be there in these situations, and this is achieved by putting various checks and balances, and on which I'll come to that later in the video. Now, there are few things which are a must-haves in an NDA. Number one, what is a confidential information? Now, we can have tons of discussion on various other things, but unless and until the meat of the matter is the confidential information. Now, someone cannot say that everything is confidential, because the very inclusion of all the, if I may say, all the non-essential items weakens the enforcement action of any NDA. So if there are 10 things, and 10 things out of that, 8 of them are publicly known information or not confidential, so to say, then the NDA is only on 20% of it. So 20% enforcement, you are like you're yourself making your document weak. So what is the confidential information amongst all the things involved? Like the source code. Okay, if the source code is deriving from open source platforms, so definitely not the open source platform. You can put it as an confidential information, because that's a publicly known information. As a result of that algorithm which brings the open source data and makes it in some distinguishable format, which is different from others, can be considered as a confidential information, or in any particular case, like a person's health information, right? now within health information there can be something which is a general information, but uh, something like his or her health records number or disease and things like that would be confidential information. And this is now this is impossible to be completely spoken about in this video, because there are thousands of contracts, and there are various every contract has its own way of interpreting what is the confidential information. And if that is taken care in an NDA, probably more than 70% of the job is done, because we have identified that out of the whole scheme of things, this small thing is the confidential information. Rest is just chaff. So number one, what is the confidential information? Number two, who owns the information? Like, there has to be like I said, there has to be a sending party and receiving party. So there has to be someone who is holding the information and can be held responsible for that. Now, the third thing is, what is the governing law? Now, you may say the governing law is not a very important thing. Something like contracts have governing law as anywhere in the world, but no. As far as the information is concerned, data is concerned, something can be considered as confidential in, say, state of California, may not be considered as confidential information in Canada or in India or wherever. So it has to be perfectly seen that, say for example, there's some trade secret which has been registered in Europe. Now, if that trade secret is not registered, like it's the judicial bodies or the trade bodies are just blind to that information. If you have a Brazilian party or a US or Canadian party, so governing law is extremely important in this case. And what is the consideration which is established? Now, you cannot have a free for run like NDA. You cannot bind any person walking on the street or to someone where there is no consideration involved. So this is the fourth thing in constituent in an NDA. And a wonderful test has been designed, or Supreme Court of Canada came up with a wonderful test in order to test whether a breach of data has happened. Now, number one is, was the information confidential which has been breached? Which, if you just go back 1 or 2 minutes in the video on which I said, the confidentiality of the information identification is very important. So, was the information confidential? Yes or no? Yes or no? Okay. Number two, was the information given in confidence? Or was it like this flown over by a kite and everyone is seeing? So was the information given in confidence? And third, has the information being misused? So third is more, I know it's more on the litigation side and fixing the culpability of data breach. So is the information misused? So these are the three tests which Supreme Court of Canada came up with. Okay, now this is the test. Now, any NDA, unless and until there aren't operational requirements tweaked and modified as per every contract, would be just a piece of paper. Now, if I am buying, say, apples, and if I am buying oranges, or if I am buying a car, an NDA cannot be same. Like, if I am buying groceries, like a bulk groceries, and if I am buying servers, so the operational requirements are different across all the different categories. So ideally, unless and until the things are very, very similar in a category, the NDA has to be statement of work driven. Like, every statement of work has to have a separate NDA which clearly states the confidential region on which the information, on which the NDA has to be executed and stamped upon. So that is extremely important. And as in one of my earlier video I said that unless and until security practices are not clearly established in the contract. Of course, they are not in an NDA, but unless and until security practices are not established, NDA becomes just a piece of paper. Like, access controls have to be there, that okay, this information would be shared by these people, or access can be accessed by these people. This information can be accessed by this B class of people. This can be accessed by C, and D can be accessed by whole organization, and things like that. The access controls, those things have to be taken care, without which the NDA becomes kind of infructuous. And there are a few other things like how are you destroying the data, how much would be the contractual obligation after like the contract ends. Generally, NDA is something which survives the termination or even the contract, like an employment contracts. The non-disclosure agreement is in force even after the contract is the employer and employee contract is terminated. And the returning and destroying of the data, how to deal with the data in case of the closure of the contract. So these are the things. The last thing I want to say, that NDA, signing an NDA is a very easy thing, but again, as I have harped upon across whole of the video, it has to be customized. A single NDA cannot be can't be good for buying apples and for buying servers. So this has to be extremely taken care of. The confidential information should be isolated, and then you have a wonderful NDA with the intended enforcement and the intended results flowing out of it. Well, that's all in my video of non-disclosure agreements. If you felt connected and the points were good to you, please do like, share and comment, and I look forward to you in another video pretty soon. Thank you.